There's a lot to unpack there, so let's speak with Barrister Ejaz Musa, the founder of One Law Chambers in London and a specialist in civil litigation. Ejaz, from the legal material that's been made public and looking at previous hearings in this case, what, in your opinion, forced both sides to settle?
What I'll say is there's a lot of tactical plays that was used by both sides in this case. If I was to narrow it down to the main aspect of why the parties settled, I think they just simply weren't ready for trial. The court gave them an ultimatum and just simply said, we're not going to adjourn this anymore. You either try this in January 2025 or you settle it. And they end up settling on the doors of trial, which is the pressure they had from the judge, which is what normally happens when you're pushed into a settlement, when you're not ready and you need to settle.
But as Prince Harry's barrister says, News Group newspapers admitted engaging in illegal practices. How was this the least worst option for them?
I think settlement has always been the strategy for NGN and NGN's lawyers. I don't think they ever wanted to take any of their cases to trial. It just turned out that the strategy didn't play out in the way it has in previous cases for them. But even admitting engaging legal practices in a settlement offer doesn't making a publicly available judgment for them, which means that normally if you accept illegal practice, you'll think a criminal sanction would apply to it. It doesn't apply in this case because it's a closed behind-door settlement offer without a publicly available judgment.
So even admitting engaging in illegal practices doesn't mean no consequence?
It's a win for them because it's admitting something without having the consequences behind it.
Prince Harry's barrister refers to claimants being strong-armed into settling. This sounds like it could be a reference to a Part 36 offer, sometimes colloquially known as a cost trap. First, what is this?
The way I would describe a Part 36 offer is a strategic settlement offer that, if not accepted within a prescribed time period, carries with it cost consequences. So that if you don't accept and you end up going to trial and don't beat that offer, or the use of the term is you don't get a more advantageous outcome than what the offer was, you will face cost consequences from the expiry of that time period, which is 21 days from the offer being made. So tactically, a number of defendants may make this offer at a very early stage. So at the expiry of 21 days, if Prince Harry's does not beat that offer, he will be liable for their costs from that point onwards. And as you've seen, this matter has been ongoing for quite some time, and 2 trials have been postponed on this case.
So if you're awarded £1 less than what you were offered in a settlement, you'd end up having to pay all costs?
I don't think it's as straightforward as £1. The court makes an assessment because some claims have non-monetary claims offers. But the court looks at the offer as a whole and looks at whether the claimant, in Prince Harry in this case, would have been minded to settle at that stage with the offer he had as opposed to what he achieved at trial, and makes that determination of whether it's more advantageous or not.
What was the original purpose of the Part 36 offers?
It's always been enshrined in law that the idea behind bring lawsuit is you should try and see whether you can settle a case as early as possible, and the court should always be treated as a last resort. So the Part 36 offers was sort of a sanction to be applied to parties who decided, oh, I'm going to have my day in court and not engage sensibly in settling this matter. And in this particular case, in Prince Harry's case, the judge was particularly critical in how the lawyers were running this case.
So you both have too many lawyers, too much time. This is taking too much of our time. Settle.
Indeed, I think that's simply the game the lawyers were playing in this case. And it came down to that they had to settle in the end.
Ejaz Musa from One Law Chambers in London, thank you.